Hello and welcome to Contemporary Issues in Criminal Justice, Week 1, Module 1. I'm going to do this module a little differently because I want to introduce the modules to you. In the module page, you see the learning objectives, you see the readings, you see the activities. And each of these, there's things for you to do. The learning objectives will tell you what you are expected to learn or to know, to understand by the end of this module. Then the readings. This particular week, you have to read Chapter 1 of your Hemmings textbook, and then the associated syllabi for each of the court cases that I have linked underneath that. You're going to have 2 discussions and 1 essay this week. The first discussion is an introduction, where you're going to introduce yourself to the rest of the class. You do have to make an original post. I would like you to respond to at least 2 students and then reply to anybody that responds to you. The second discussion that you're going to have today is a discussion on the exclusionary rule, and more specifically Weeks versus United States, and what the exclusionary rule means to you as a criminal justice professional. The third assignment that you're going to have to do today is a 2-page essay. It must be in APA format, and what I want you to discuss in that essay is the evolution of the Fourth Amendment and the searches that go along and how the Supreme Court defined what a search is and what a search isn't, going through the 2 tests that the court established, the first test being a property-based trespass test, and the second being a reasonable expectation of privacy test, and the several different court cases that go along with both of those tests, constitutional tests that were put together by the courts for us as criminal justice professionals to follow. You really cannot start any discussion on the Fourth Amendment without first understanding the Fourth Amendment. The Fourth Amendment reads as follows: the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, support by oath or affirmation, and particularly describing the place to be searched, the persons or things to be seized. That is the Fourth Amendment. And that is our question. What does the Fourth Amendment mean? And if there's a violation of the Fourth Amendment, how are those items, that evidence, excluded from the record? Okay. As we go on, we will address more. The first cases that we're going to be reviewing are the property-based trespass test cases. These cases, there are 3 of them. Olmstead versus the United States, 1928, deals with wiretaps. Goldman versus the United States, 1942, deals with a detectaphone. And the third is Silverman versus the United States, a 1961 case that dealt with and specifically addressed what's known as spike mics. These are the 3 cases that establish the property-based trespass test, and we will look into them in more detail in the next slide. Olmstead versus United States is a 1928 case that referred to and looked into wiretapping and wiretaps. Again, this was in 1928, and as a side note, piece of little trivia for you for your next Trivial Pursuit game. The justice that wrote the opinion for this case was Chief Justice William Taft. He was the only president of the United States who also served as the Chief Justice of the United States Supreme Court. That being the trivia note, let's move on. What the court and Justice Taft stated was that wiretapping is not considered a search or a seizure covered and protected by the Fourth Amendment because the agents and the police officers that were involved attached a listening device, a wiretap, to the phone lines outside of the house and outside of the curtilage of the house. And the court stated that searches and seizures of the person, his papers, and other tangible material effects included his home, his office, and his curtilage, and that the Fourth Amendment does not protect telegraph or telephone messages, and thus there is no search involved, and a wiretap was considered constitutional because the person intends to project his voice outside of his house. Okay. In Olmstead, they believed and they said that the protections was for an individual to be able to retreat into their home. The dissent in this case stated that this was going to be a problem in the future, and as we find and as we have now, wiretaps are now part of privacy. But Olmstead did establish the first part of the physical trespass rule. Officers and agents were not allowed to trespass against a person's home, his castle, or his items or his things without a warrant. Goldman versus United States, 1942. In this particular case, we were looking at the detectaphone. And what the agents did was they obtained access to Schulman's office, not into his office, but into his office building and into the office next to his. And they went into the gap in between the walls. And inside that gap, they put a listening device. They attached a listening device to a headset, and the agent was allowed to take notes. When they tried to activate and use this method the next day, it didn't work. So they used a detectaphone, and the detectaphone amplified and recorded the discussions that were going on in Schulman's office. So basically what they did was they took a glass and they put the glass up against the wall and they put their ear up against the glass. You've done this. I don't know how many times you've done this as a kid to listen to what your parents are having to say. You've seen it on TV. Well, this is what the federal agents had done. And they used that information and testified against them, and they were convicted of the crimes that they were charged. They appealed, and Schulman and Goldman argued that the evidence was obtained in a violation of the Fourth Amendment of the Constitution and should have been excluded because of their privacy. The Supreme Court, reaffirming Olmstead, stated that the detectaphone by government agents, the use of such instrument by government agents, was not a violation of the Fourth Amendment because there was no intrusion into the office and the personal private property of Mr. Schulman. Okay. And the court stated, or the petitioner stated, that one talks in his own office and intends his conversation to be confined within the four walls of the room. However, if you've ever been into an office, you can hear what's going on in the next office over. So we should know that our discussions, even behind closed doors, can be overheard, and we should show our understanding of that. The court said that the distinction is too nice for practical application of the constitutional guarantee, and no reasonable or logical distinction can be drawn between what the federal agents did in the Goldman case and what the state officers did in the Olmstead case. They never entered Schulman's office. There was no physical trespass. Therefore, the listening devices were determined constitutional. Silverman versus the United States, 1961. The issue at hand in this case was the use of a spike mic. And what happened in this spike mic, or what the agents did, was they were investigating Mr. Silverman and his accomplices. And they were investigating them for gambling and gambling issues. They lived in a house Silverman and others lived in the house, which had an adjoining wall with the next door neighbor's house. The next door neighbor's house was vacant, and agents went in there. And much like in the Goldman case, in the Silverman case, they used a listening device called a spike mic, which is a spike that's about a foot long. It has a microphone on it. It has a amplifier and earphones. And the officers took this spike mic and they put it underneath the floorboards, not the baseboards, not the floorboards, but the baseboards of the walls that separated the two homes. And they sent it all the way intruded into the Silverman home until the spike mic hit a heating duct. And because of the heating duct went throughout the house, it turned into a great conduit, and the officers were able to record everything going on in the Silverman home and convicted them. The Supreme Court turned around and actually stated that this was unconstitutional and was a violation. Because it was an intrusion into the home. And because the spike mic actually went into the home, this was a violation of the Fourth Amendment. And the court concluded that the Fourth Amendment protects the right of a person to retreat into his own home free from unreasonable government intrusion. Thus, a federal officer may not, without a warrant and without consent, physically encroach into a person's office or their home and secretly observe or listen to them, and later testify about those conclusions. And everything in that was attached to this had to have been excluded from the case. These are the trespass intrusion cases, and we are going to be moving on in the next slide and talking about the reasonable expectation of privacy. As we have learned, the property trespass test was adopted and applied by various courts and cases, specifically set and originated with Olmstead versus United States in 1928. And this case made it possible for law enforcement officers to use technology and surveillance devices that did not physically intrude upon constitutionally protected areas of the home and the office and the curtilage. This became a problem as our community and our society advanced in technology. And aware of these advances, the court, specifically the Supreme Court, expanded upon the protections guaranteed by the Fourth Amendment to include not only the trespass and the property trespass test, but also the privacy rights of the people instead of places. So now individuals are protected based upon an expectation of privacy. And the test is called the reasonable expectation of privacy test. And the cases that are associated with the reasonable expectation of privacy test include Katz versus United States in 1967, Marion versus United States in 1978, Dow Chemical Company versus United States, 1986, United States versus Knotts in 1983, United States versus Karo in 1984, California versus Cirallo in 1986, Florida versus Riley in 1989, Cayo versus the United States, 2001, and the United States versus Jones in 2012. These cases have established the primacy of the reasonable expectation of privacy test. Katz versus United States, 1967. During the trial, the prosecution presented petitioners' telephone conversations heard by federal law enforcement agents through an electronic listening device that recorded the discussions to the phone lines of an exterior to a public telephone booth. The court held that the Fourth Amendment protects individual privacy against certain kinds of governmental intrusion. And although Olmstead required a physical intrusion into property. Katz, in turn, decided and stated that the Fourth Amendment protects people and not places. What a person knowingly exposes to the public, the court said, even in its own home or office, is protected by the Fourth Amendment. Also, what he seeks to preserve as private, even in an area accessible to the public, may be constitutionally protected. The court continued and stated that a person who enters into a phone booth and shuts the door is entitled to assume that the words that he utters into the mouthpiece is not going to be broadcast to the world. He has an expectation of privacy, and he believes that his conversation is private. The courts conceded that, absent physical penetration, was at one time thought to be the Fourth Amendment and important and mandatory for the Fourth Amendment protections, as stated in Olmstead. The court said the premise that property interests control the right of the government to search and seize has been discredited. Okay. Olmstead said there had to be a physical trespass. Katz, the court said, not only the seizure of tangible things, but this extends to the recorded conversation overheard without any technical trespass under local property law. Your discussion, according to Katz, your discussions and communications with another individual, if they're expected and there is a reasonable expectation that that discussion is private, the government cannot use listening devices to record and then use as evidence as chief against you. Marion versus the United States was a beeper tracking case, and using a beeper to track the actions and motions and positions of Marion and his partner. What happened is they rented a Cessna, and they had arranged to rent a Cessna for 1 week. Prior to the start of the rental period, the Drug Enforcement Agency, the DEA, pursuant to a warrant and with the consent of the owners, installed a beeper into the aircraft, and they tracked the locations and the activities of that aircraft using a United States Customs aircraft. Okay. They tracked him down to Mexico and then back to the United States. He landed in an airport in California, and he was arrested while transferring several hundred pounds of marijuana from the airplane to a pickup truck. The petitioners were tried separately and convicted separately of conspiracy to possess a controlled substance with the intent to distribute. The defendants, or the petitioners in this case, Marion and his partner, argued that the installation of the beeper and the monitoring of its signals constituted a search and seizure within the meaning of the Fourth Amendment. Well, it went through to the Ninth Circuit Court of Appeals, and the Ninth Circuit Court of Appeals stated that the installation of a beeper and the monitoring of its signals was not a violation of the Fourth Amendment. The court held that there was no distinction between visual surveillance and the surveillance through an electronic tracking device. Thus, the use of the beeper to monitor the aircraft technicians did not infringe upon reasonable expectations of privacy. In its denial of certiorari, the Supreme Court noted and cited United States versus Moore and the United States versus Holmes. In these cases, conflicted each other. One stated that because the cars were on the road and there was a lessened expectation of privacy, I justified the expectation of use of beepers without a warrant if the officers had articulable probable cause. In Holmes, the court stated that the 300 pounds of marijuana that were seized was a violation, and the Fifth Circuit Court of Appeal affirmed the district court's order to suppress all evidence obtained through the use of the beeper. So there is a split court's decisions on this matter at the moment. However, the court did state, and the Supreme Court held in this specific case, that it was denying certiorari and that it was not going to grant certiorari unless an action would appear to offer the strong likelihood of deciding an issue on which the square conflict exists. There is not a conflict at this matter. There was a warrant, and there was consent to place the tracking device upon this airplane. So the Supreme Court refused to hear it, and Marion's conviction was upheld. Dow Chemical Company versus the United States. In this particular case, Dow Chemical was approached by the EPA, and the EPA wanted to do an inspection of the 2,000-acre chemical plant that consisted of numerous covered buildings that were exposed to visual observation. Dow Chemical denied the request by the EPA for an outside inspection of the plant to look for contaminants. And the EPA did not turn around and seek an administrative search warrant, but conducted aerial surveillance. What they did was they used photography, a mapping camera, and a aircraft. They went at different altitudes, levels of 12,000 feet, 3,000 feet, and 1,200 feet over the Dow Chemical plant and area, and brought complaints and filed fines and charges and administrative fees against Dow Chemical for their violations. Dow Chemical brought suit in the District Court of Michigan against the EPA, citing that aerial photography violated the Fourth Amendment. The Supreme Court turned around and held that the warrantless aerial photographing of the plant from an aircraft that was lawfully navigating public airspace was not a search prohibited by the Fourth Amendment. They continued and stated that reasonable and legitimate expectations of privacy that society is prepared to accept is the intimate areas and family privacy in the home and its curtilage do not extend to the outdoor areas and spaces of a manufacturing plant. So the protections that are given to families and individuals did not extend to Dow Chemical or any other private manufacturing industry. It is seen as open areas, and the open areas of the industrial complex are considered open fields, which brings about a really cool DEA joke that I may or may tell you here in a second. But the mere fact that human vision is enhanced to some degree does not give rise to the Fourth Amendment of constitutional protections. The EPA and the federal agents were at a place that they were legally allowed to be, and they were taking pictures of open fields and open areas. This actually fell into, the Dow Chemical lawsuit actually fell into what we commonly know as plain view. And no, I'm not going to tell you the joke today. United States versus Knotts, 1983. In this case, beepers come up again, and the use of beepers to track criminality and criminal activity. The courts further reviewed the issue in the situation of using beeper tracking devices, and the courts did hold in Knotts that there was no Fourth Amendment violation in the warrantless use of beeper tracking. The court did, however, acknowledge that dragnet type technology enhanced surveillance when conducted in public spaces may not always survive constitutional scrutiny. The court at this time reserved the right to further review the use of beeper tracking devices as a dragnet type of information. But what was going on in the case of Knotts? Knotts was involved with the illegal manufacture and distribution of methamphetamine, in addition to other drugs. And relying upon beeper technology, police officers, without a warrant, asked the owners of a chemical company to install a beeper inside of a 5-gallon container which contained chloroform, which, as criminal justice professionals, you guys know that chloroform is one of the chemicals that's used to manufacture methamphetamines. So they knew that Knots went to this same dealer all the time to buy his chloroform. They asked to put a tracking beeper inside the 5-gallon bucket, and then they tracked that bucket to its destination using visual surveillance and by using the tracker, the beeper tracker. They followed the chloroform to Knott's cabin, where they placed the cabin under surveillance for 3 days, used the information that they gathered to go get a warrant. Upon the execution of the warrant, they discovered a methamphetamine drug lab in the home. They were convicted and sent to prison for 5 years. A divided panel of the Court of Appeals at the Eighth Circuit reversed the conviction, stating that the tracker violated the reasonable expectations of privacy of Mr. Knotts in his travels. The Eighth Circuit stated that an individual has the right to privacy of their comings and goings. The United States brought this to the Supreme Court, and the Supreme Court decided that an objective expectation of privacy that's what they looked at. They looked at the issue of whether or not an individual had any objective expectation of privacy in his movements. The court found that the defendant did not have any expectation of privacy while traveling on public roads. And traveling on public roads implies consent to be viewed by anyone who is physically capable of doing so, including law enforcement officers. They stated that the beepers are merely a more effective means of observing what is already public. Okay, more efficient and effective raises no constitutional objection, and using the beeper as a tracker was not a violation of the Fourth Amendment. So as long as the suspected criminal activity target for surveillance was susceptible to observation from a publicly accessible space. And in fact, that, back to the plain view doctrine, the police officers were where they were allowed to be legally. They were tracking the criminals legally through a tracker that was put into a container with the consent of the owner of that container at the time that the tracker was placed. The court did, again, expressly reserve the issue for further consideration, concluding that if dragnet-type investigatory techniques should occur, that there will be time enough to determine whether different constitutional principles may be applicable. But as long as the tracker and the beeper is being used to track on public access and public roads, it is constitutional. And United States versus Karo, a case that delved a little more, and we will talk about in the next slide. We'll go into this a little more, where we will continue the use of beeper tracking. The United States versus Karo 1984 is our third case that looks into the use of a beeper tracking device. In this case, much like Knott's, drug dealers had planned to obtain 50 gallons of ether and then to use the ether to extract liquid cocaine that had been dried into clothing that have been brought into the country. And then this way you can extract the cocaine out of the clothes, dry the cocaine, cut the cocaine, and sell the cocaine. But they needed ether to do this. And an informant advised the DEA that Karo, Horton, and Harley, the three defendants of the case, was about to do this. The DEA substituted one of the cans of ether with one of their own, which included a beeper tracker. The agents tracked the movement of the ether inside one of the petitioners' homes using the beeper. Then it moved to a storage shed, and then it went to another home. This ether moved around quite a bit before it was finally placed in a home and actually used. Using the beeper monitor, the agents determined that the beeper was still inside this last home, obtained a search warrant for the house based upon the fact that the informant had talked about the defendants using the ether to extract cocaine. A warrant was issued, and a search was conducted, and the respondents were indicted for various offenses relating to the cocaine and drug trafficking industry. The Supreme Court held that there was no Fourth Amendment interest in Karo or any of the other respondents, and none of their rights were infringed upon by the installation of the beeper. The informant's consent for the installation of the beeper was enough to validate it and to make this a legal activity on part of the law enforcement. The court further stated that the beeper container was not a search or a seizure because it did not convey any private information. It did not interfere with anyone's possessory interest of privacy in any meaningful way. The monitoring of the beeper in a private residence not traditionally open for visual surveillance did violate the Fourth Amendment rights of those with a justifiable interest in the privacy of the residents. However, identifying and knowing that the beeper was in this residence was not a violation, and that there was no reason in this case, the Karo case, to deviate from the general rule that a search of a house should be conducted pursuant to a warrant, and they actually had a warrant in this case. The court held that the evidence seized in the house should not have been suppressed with respect to all of the respondents. Information on either the ether's location within the home, verified by the warrantless use of the beeper, was inadmissible only against those respondents with a privacy interest in the home, and invalidated the search warrant as to them specifically. Karo and his co-defendants did not have that expectation of privacy. So using beepers, the government and the courts have dictated that as long as the tracking is being done in public spaces and not in private spaces, it is acceptable to do so. We'll be moving on to the open fields doctrine next. In Oliver versus United States, 1984, it set the opinion on the open fields doctrine. And although the case of Oliver versus the United States did not involve the use of surveillance technology, this case did mark a turning point in the court's analysis on privacy rights, specifically in open fields, as opposed to the home or the curtilage surrounding it. Okay, the court did clarify that searches conducted in open fields are not protected by the Fourth Amendment, which brings back my joke. Okay, however, let me finish with this. The open fields doctrine was explained that inside the post Katz jurisprudence, an individual may not legitimately demand privacy for activities conducted out of doors in fields except in the area immediately surrounding the home. So the court stated that that area immediately surrounding the home is known as the curtilage and is protected under the Fourth Amendment by reference to the factors that determine whether an individual reasonably may expect that area immediately adjacent to his home will remain private. Open fields are not private. So the joke may offend some, may not. Some of you might have heard it out here in West Texas in the ranching life. It might be funny. So this DEA agent goes up to his rancher and says, "Mr. Rancher, I need to search your back 40. We believe that you're growing marijuana back there." The rancher goes, "This is my ranch. Where's your warrant?" The DEA agent takes out his badge and shows it to the rancher and says, "I don't need no warrant to search your field. Oliver versus United States says I can search any field I want. You have no right to privacy." And the rancher goes, "Oh, okay, I understand. You're free to go do whatever you want, I guess. Just do not go into this field. This field is not safe for you to go into." The DEA agent responded, "I'll go into whatever field I want to. I don't need your permission. I was just giving you common courtesy." The rancher said, "Well, yes, sir. You have the badge. You have the right. You can do whatever you want. I'm just recommending that you not go into this field." The agent jumps the fence into the field that the rancher told him not to go into and says, "I'm a DEA agent. You can't tell me what to do." Rancher lights up a cigarette. He's leaning there up against the post, smoking a cigarette, watching the field, and all of a sudden, he hears this DEA agent screaming to the top of his lungs, screaming, "Help me, help me, help me. Stop this bull. It's trying to kill me." And the rancher looked up and yelled back to the DEA agent and said, "Show him your badge." Anyway, so this is open fields doctrine. The court did reserve the right for future cases to discuss the issue of whether and to what degree aerial surveillance could be resorted to by law enforcement officers without violating the Fourth Amendment. And those cases with California versus Cirallo and Florida versus Riley, and we will get to them next. In California versus Cirallo, 1986, and Florida versus Riley in 1989, the courts addressed open fields more specifically into the curtilage. And as we know, the curtilage is that area that surrounds the home where it's intimately linked to the home, both physically and psychologically, where privacy expectations are mostly heightened. The things that you do in your backyard, the things that you do in your front yard, is that a constitutionally protected area where the police should shield their eyes as they're driving by, or not? Well, in this case, what happened is that Mr. Cirallo had a privacy fence in his backyard, and in his backyard he was growing marijuana. The police at a altitude of 1,000 feet had aerial observation of the backyard within the quote-unquote curtilage of the home. Law enforcement officers had received telephone tips that marijuana was growing in his backyard, so they went and looked. Based upon the information from the tip and the pictures that they took from a standard 35mm camera, they were able to obtain a search warrant on the basis of the affidavit describing the marijuana. The California Court of Appeals reversed the conviction, stated that The warrantless aerial observation of the respondent's yard was unconstitutional and violated the Fourth Amendment. The Supreme Court, on the other hand, the state of California brought this to the Supreme Court, and they held that the basis of the Fourth Amendment scrutiny is whether a person has a constitutionally protected reasonable expectation of privacy. As mentioned back in Katz, there was a two-part inquiry that was looked into based upon the claim of privacy. And the first was whether the individual had manifested a subjective expectation of privacy in the object of the challenge search. The second was whether or not society is willing to recognize that expectation as reasonable. If I put a 7-foot privacy fence around my house, I would expect that any reasonable person would want to believe that I was expecting privacy. However, the air doesn't count. The court turned to the second prong of the Katz test and considered the history and the genesis of curtilage doctrine. They pointed out that under common law, the curtilage is the area that extends into the intimate activity associated with the sanctity of a man's home. The court held that although the area of the curtilage, not all forms of police observation are barred. Police officers are not expected to cover their eyes and not look into the curtilage area where they are legally allowed to be. Okay, so the Supreme Court stated that aerial surveillance is allowed, and this evidence was admissible because it was readily discernible by the naked eye as marijuana from 1,000 feet in the air. In Florida versus Riley, the enforcement officers similarly conducted aerial surveillance from a helicopter at an altitude of 400 feet. During the surveillance, police officers saw a partially uncovered greenhouse with marijuana plants growing in it. The court upheld the constitutionality of the warrantless helicopter surveillance. They were where they were legally allowed to be and was able to observe through what we commonly know as the plain view doctrine. In Karo versus United States 2001, the Supreme Court addressed the use of thermal imaging devices by law enforcement as a way to conduct surveillance upon a home. What had happened is that the law enforcement agents had used a thermal imaging device on a home, and they realized that it could be attributed to measure the intensity of the heat emanating from a house. And if that level of heat could be attributed to the high intensity lamps that were normally used for indoor marijuana growth. And using these heat detectors, police officers were able to get search warrants and arrested Kylo in his home for growing marijuana. The Ninth Circuit Court upheld the thermal imaging on the grounds that Kylo did not have any subjective expectation of privacy because he did not attempt to conceal the heat waves from coming from his home. The Supreme Court reversed the Ninth Circuit and remanded the holding and sent the case back to trial because in the holding that the device was not in general public use, and meaning that not anybody could just go down to Home Depot and buy a thermal imaging device and use it driving down the street or whatever, looking for heat. The court reiterated its ruling in Katz versus the United States that a search does not occur unless the individual manifested a subjective expectation of privacy in the searched object and society is willing to recognize the expectation as reasonable. Under common law, a homeowner has the reasonable expectation of privacy within the interior of his home to be private and his own business. There have been several other cases relating to other behaviors, such as Lawrence v. Texas in 2001, also in 2001, that insisted upon this level of expectation of privacy within your own home. Thus, the Supreme Court stated that this was an unlawful, unreasonable search, and that the police physically intruded into the constitutionally protected area through the use of a sense-enhancing technology that is not in general public use. United States versus Jones, a 2012 case, the Supreme Court reviewed GPS systems for tracking, and they returned to the property-based trespass test that was originally brought to us in Olmstead versus United States back in 1928. In the United States versus Jones, the government obtained a search warrant to install a GPS tracking device on a vehicle that was registered to the defendant's suspect's wife. The warrant authorized the officers to install the device inside the District of Columbia within 10 days from issuance. The officers did not install it until the 11th day, and also installed it in Maryland instead of the District of Columbia. So this became a warrantless search. There was no approvals from the courts to proceed as they did. They tracked the vehicle's movements for over 28 days. The district court suppressed the GPS data obtained while the vehicle was parked at the Jones residence, but held that the remaining data was admissible because Jones did not have any reasonable expectations of privacy when the vehicle was traveling on the streets. The D.C. court reversed the holding that the warrantless use of the GPS device violated the Fourth Amendment. So the Supreme Court picked this up, and it held that the attachment of the GPS device to a vehicle and its use of that device to monitor the movements of the vehicle for 28 days did constitute a search under the Fourth Amendment. They stated that the Fourth Amendment protects the right of the people to be secure in their persons, houses, papers, and effects against unreasonable search and seizure. The government physically intruded upon the private property, this being the vehicle, to obtain information. This physical intrusion for the purpose of obtaining information constituted a search. They found that the activities was a violation of the Fourth Amendment, and ordered that all of the evidence that was obtained be excluded. The later cases that deviating from the property-based approach applied a reasonable expectation of privacy. And what the court stated to remedy this apparent confusion was that the reasonable expectation of privacy test had been added to, not replacing or substituting the common law property-based trespass test. So both of these tests, according to the court, work in unison. Is there an expectation of privacy, and is the police or law enforcement intruding or encroaching on the private property of the citizens? So in conclusion, the Fourth Amendment has specific protections for the citizens against unreasonable government intrusions into their lives, both supervised or monitored or evaluated on the basis of the property-based trespass test and the expectation of privacy test. And the expectation of privacy test and all of it works together in the belief of, is there a expectation of privacy upon or held by the suspect or by the citizen? And secondly, is that expectation of privacy accepted as reasonable by society at large? Whenever we as criminal justice professionals start looking into warrants and to the actions that we take in a surveilling citizens, we have to keep these two aspects, these two tests in mind. Are we violating or encroaching upon the privacy interests, whether it is property-based or individual-based, of the citizens? In Jones, the decision was favorable to the petitioner, who was guaranteed the Fourth Amendment protections against government intrusion. As you lead your troops, as you lead your officers, you need to make sure that the actions that they are taking fall within these expectations.